Good evening and welcome to the regular meeting of the San Francisco Ethics Commission. We will begin by taking the roll. Vice Chair Rennie.
Present.
Commissioner Han. Here. Commissioner Andrews.
Here.
Commissioner Keene.
Here.
All members being present, the first item on the agenda is public comment on matters appearing or not appearing on the agenda within the jurisdiction of the Ethics Commission.
I'm Bob Planthold. I came to talk about a need for timeliness in responding to complaints, both those filed directly with you as well as those referred by the Sunshine Ordinance Task Force, because I'm involved in both aspects of complaints. There was an incident in December of 2013 which I complained about nearly a year ago. I've never heard a response. Nothing. Not even to say we're looking into it. It doesn't come within our jurisdiction. Silence. And that's a problem because when I was on the commission with Mike Garcia, what seems like eons ago, we both talked about whether complaints could become stale and run past a statute of limitations. So the fact I haven't heard makes me wonder, maybe I had a valid point and it's dead now? But I want to talk also about those complaints referred to you by the Sunshine Ordinance Task Force, because I've also had complaints filed with them where I got a unanimous or overwhelming vote. When they would be referred to you in the past few years, I would sometimes get a response, "We don't think this would hold up in court." Well, before I was on ethics, I spent 7.5 years on the Sunshine Task Force. Never was there anywhere in the law, in any draft of amendments, in any instructions to Sunshine Task Force from ethics, any draft of anything saying there has to be a court lawsuit evidence quality case presented to ethics. I don't disagree. Maybe you feel that's important, but that's never been communicated to the task force. It's never been communicated to complainants. So when we make a complaint, and I had several overwhelming or unanimous decisions, and they all get figuratively blown away, that raises question about what are you paying attention to? What are your criteria? Why is it just this bland, broad statement? It doesn't meet the evidence standard for a court case. Why is that not made known to the larger public and to the task force? That's the question of the timeliness of response to complaints on both ends, those filed directly with you and those referred by Sunshine. And I brought that up because in another matter coming before you, I see minutes from 2008 where there are some people who talked about the need to have a Sunshine complaint have a priority. Maybe, maybe not, but certainly dismissing complaints that have such overwhelming support really seems like you're not paying attention to the task force. Maybe they need education, but you got to do it. You can't just say no and walk away.
Could I get the overhead? Oh, there we go. Members of the Ethics Commission, Ray Hartz, Director, San Francisco Open Government. I'd like to read this from this quote from Justice Anthony Kennedy in the Citizens United case. The government may commit a constitutional wrong when by law it identifies certain preferred speakers. By taking the right to speak from some and giving it to others, the government deprives the disadvantaged person or class of the right to use speech to strive to establish worth, standing, and respect for the speaker's voice. The government may not by these means deprive the public of the right and privilege to determine for itself what speech and speakers are worthy of consideration. The First Amendment protects speech and speaker and the ideas that flow from each. I would like to agree with Mr. Planthold on your timeliness. And here's why I agree with it. I've got 19 orders of determination, every one of which has failed to be enforced by you. The last one you had a hearing on was the city librarian, and you held the hearing. You announced it the day I left the city to go out of the state and held the hearing the day before I got back. I was never given any notice by either email or postal mail that a hearing was even being held. Now, when it gets to the point where you can't just dismiss them like you have in the past, where you have to do an end run and hold a hearing while somebody's out of the state, I think some real questions need to be answered. And when you look at it 19 times, 19 orders, are you going to say they're all faulty? This is a pattern of behavior of city government where because I speak about things they don't want spoken about, or I want access to records they don't want to give me, they just decide they aren't going to follow any of the laws. And if you look at these cases, each of them is a First Amendment case because it either affects my ability to speak, my right to have that accurately represented in the official record of where I'm speaking, and the right to access public records, which I need to effectively exercise my First Amendment rights. Now, is any of you going to sit there and look me in the eye and try to tell me that 19 cases, not one of these was worth your consideration in fairness? I've come to you before and I've said that the Good Government Guide, which you like to quote all the time, says you have to give the appearance of fairness, and you don't. You can't look at these 19 cases, most of which have been referred to this body and never had a hearing, and say in any way, shape, manner, form that you are in any way being fair to me. And believe me, I'm not paranoid. There are other members of the public who go to these bodies and try to say stuff or try to get public records, and they're denied it. I just have the perseverance to take it through the whole crap deal you have to deal with to get these orders. When are you going to get off your backsides and enforce the law? That's what the Sunshine Ordinance says. This body is responsible for enforcing the law.
I guess I would be one of those people who's having an enormous amount of problem. Unfortunately, I'm an artist, and I have a simple permit through the San Francisco Arts Commission. It is a mess. They have a communications officer, Kate Patterson, who does not communicate. If she decides to give over documents, they're completely irrelevant. She bombards me with 20 to 40 emails a day. This has been 5 days a week for the past 2 years. The majority of my time has just been getting simple documents, simple questions asked regarding permit renewals, a little bit of information here or there, and I can't get it. I'm not going to take you through what it's like to work in a situation like that, but in 2013, they held a hearing to revoke my permit without even noticing me. They denied my due process rights. I was in the hospital when the hearing took place. I was slandered. They do not know how to run public meetings at all. Mr. Hartz was there, defended me, and they also, it was only by doing a public record search on my name that they filed a concurrent civil stalking case at the same time. So I had to wait for that to close out. 3 months later, I filed an appeal, and I won. And since that time, I've been almost afraid to work in the street. It's not a fear of retaliation. It's just lying in logbooks, inventing incidences that haven't happened, trying to get bits and pieces of information. Point me to the code, point me to the ordinance, point me to the section that would be regarding bottle caps, as stupid as it may sound. And they can't get it together. And every day I go through this. I am afraid to go to their office. Last month when I went there to renew a permit, you ring a buzzer to get in the door. They don't answer the phone, and they don't respond to emails unless they're IDRs. So I rang the buzzer. It was during business hours. You go present a money order. It takes a few minutes. Instead, they denied me access. The office manager, a woman who I don't know, ran down to the guard's desk and claimed to call 911 that there was a restraining order against me. There is no restraining order against me. I've endured this for 2 years, and it's really unbearable. Thank you.
Mr. Chair,
Yes, Commissioner
may I ask a question?
Dean, yes.
What sort of permit was denied of you? What kind of permit are you talking about?
It's called a street artist permit. I have it in my bag, and it's just gotten to the point where my health is at stake. It's really unbearable for me.
Thank you.
It's through the street artist program.
The next item on the agenda is discussion and possible action regarding a forfeiture letter sent to Supervisor Farrell on December 9th, 2014. Mr. St. Croix or Mr. Minardi, do you want to introduce this matter?
Chair Herr, I just want to, I need to recuse myself from sitting up here for this matter. So, thank you.
Sure.
So the commission had determined at the last meeting to request that Mr. Farrell respond to the forfeiture letter that the staff issued in December so that they could determine what, if any, further actions to take on this particular matter. I believe someone representing Mr. Farrell is here.
Is there a representative of Mr. Farrell here?
Thank you, Commissioners, for the opportunity to discuss this matter. As you know, we submitted a detailed letter outlining the reasons why we believe very strongly that forfeiture is not warranted in this matter, and really request on Supervisor Farrell and his committee's behalf a complete waiver of the forfeiture request. Most notably, and very importantly, Supervisor Farrell has done absolutely nothing wrong. The FPPC conducted a 2.5-year investigation where they interviewed everyone involved with the Farrell Committee, everyone involved with the Common Sense Voters Committee, looked at, hundreds if not thousands of emails, and they completely exonerated Supervisor Farrell and determined that he had not taken any action that warranted any type of fine. Yet here we are, basically 5 years later, 2 elections later, with a letter demanding that he pay $191,000 personally. And we just believe that there's absolutely no factual or legal basis for such an incredible request. Again, most notably because he did not violate the law at all. Also, on a more procedural ground, as has been discussed a lot, the statute of limitations, which is 4 years, clearly bars the Commission from asking for a forfeiture at this point in time. If the Commission wanted to ask a committee to forfeit money back to the city, which the law says it can do, very clearly, your own policies say you have to do that within 4 years, which in this case would have been by October 2014, 4 years from when the Common Sense Voters did whatever it did. Now, there's been talk, that there was fraudulent concealment, and that's why the statute of limitations doesn't run. And talk about, until the FPPC issued its stipulation, then forfeiture didn't apply. But those arguments simply aren't true. The Commission was put on notice, received a complaint in December 2010, from the Riley's attorneys, alleging that there might be coordination between Supervisor Farrell and this committee. But regardless of that complaint letter, Commission staff actually sat in on the interviews with the FPPC. The FPPC, when they interviewed the rogue consultant, the consultant to Farrell's committee, who did these actions without his approval, staff of the Ethics Commission was there. There's no concealment. That was in 2012. Clearly, the Commission could have concluded its investigation and decided whether to act within its own policy, within the 4-year statute of limitations. If it was in these interviews in 2012, there's absolutely no reason why the Commission couldn't have requested forfeiture before October 2014, but it didn't. And because of that, and because these rules are very clear, it can't now, 2 election cycles later, ask for forfeiture. The other thing about forfeiture that we point out in our letter is we really do not think that forfeiture, which is kind of a term of art, is appropriate in this case. As Mr. St. Croix has said, forfeiture is authorized by the law in really a very limited number of circumstances. It's when a committee files a report, and from the face of that report, it's obvious the committee has accepted a contribution which violates Section 1.114, meaning it's over the limit, it's from a corporation. So a committee files a report, which frankly, for better or worse, happens all the time, and they say, $500 contribution from ABC Corporation. Well, there it is. You don't need to investigate. The committee has effectively admitted it accepted an illegal contribution. Or what also happens all the time, the committee will disclose receiving $300 from Sue Smith on one date, and then 6 months later receives another $300 from Sue Smith. You add them together, it's over $500 contribution limit. Again, as Mr. St. Croix has said, no investigation is needed in order to reach the conclusion that the committee should forfeit the money. And obviously, and we asked the Commission for records of all of its forfeiture matters, and there are about 100, don't quote me on that, and in every single one of those, it was a corporate contribution, it was over the limit, it was missing occupation employer information, where there was absolutely no question from the face of the report that the committee had accepted a contribution it shouldn't have, and that's why the city could ask the committee to forfeit the money. Look where we are here. We're only here because of a 2.5-year investigation which involved 10 interviews, hundreds of documents and emails being produced. So by definition, this is not the type of matter which forfeiture really relates to, where it requires a full investigation. That's not what forfeiture is all about. And kind of the footnote to this point is, besides the fact that this Farrell Committee is long since closed, it's really kind of an abstract argument that's kind of hard to make. But the Farrell Committee never received $191,000. This other committee evidently spent $191,000 on mail pieces that supported Supervisor Farrell's candidacy or opposed his opponent, but that money was never received by the committee. So simply on kind of basic semantics, how can you be asking a committee to forfeit money that it never received? Besides the fact that the committee has been closed for, I'm not certain exactly when, but for years now. So, and talking to Mr. St. Croix, when we raised these issues with him, and he's been cooperative, and we've certainly, Supervisor Farrell, when he got this letter, immediately contacted the commission and immediately started talking, wanted the commission to understand, his position. And the implication is that even though his committee's closed, that perhaps Supervisor Farrell will have to pay this personally. So kind of in sum, in order to get to forfeiture in this matter, the commission has to blow through the statute of limitations. It has to apply this provision of law to a situation which is different than any situation it has ever applied forfeiture before. And it has to ask Supervisor Farrell to pay this money, whether it's $191,000 or something else, out of his pocket. And this is in contrast to the one investigation in this matter, the only investigation, has completely exonerated Supervisor Farrell of any wrongdoing. Given these facts, given this law, we certainly believe that forfeiture in any amount is not warranted. And again, we respectfully request that the commission agree with us and waive this forfeiture request. Certainly, if you have any questions about our letter or otherwise, I'm here to answer them.
Any questions from the commissioners? Commissioner Rennie.
Just a couple questions. One is, putting aside the statute of limitations, putting aside that defense,
Right.
What remedy is there where a candidate sets up his campaign, his election committee, and ostensibly sets up a independent committee which does pieces against his opponent,
Right.
And it's determined that independent committee, quote, was not independent,
Right.
but was controlled by the candidates committee.
Right.
What remedy is there when that occurs?
Of course. Well, first of all, we think it's very important to point out what the FPPC investigation found was that a consultant hired by Supervisor Farrell's committee, Chris Lee, without any knowledge or approval of Supervisor Farrell or anyone else on the campaign, sent, 2 or 3 emails to this independent expenditure committee at the very beginning. That's all the FPPC investigation found. Okay, so it's not based on what, we know what the FPPC has released publicly and what we've seen, that there's not evidence. Certainly it is unfair to say that Supervisor Farrell, the candidate, set up or ran this committee. So saying that, there is a whole panoply of remedies available to the Ethics Commission that are clearly laid out in the charter, clearly laid out in your own enforcement regs, where you open an investigation, you interview the prospective parties, you talk to the city attorney's office, you apply the facts to the law, you decide whether you think a violation has occurred, you talk to the respondent, and what most of the cases, as you know better than I do, they're settled through some kind of stipulation where the Ethics Commission has the authority to levy fines up to $5,000 per violation. And if a settlement's not reached, then you go to a full hearing and maybe you go to court. There's a full panoply of enforcement.
But forfeiture is not one of the remedies that could be imposed.
We wouldn't think so. I guess that, again, forfeiture is appropriate if there's no investigation needed. So I don't want to forestall the possibility that some committee could file reports, and on the face of those reports, somehow they admit to coordination. Then I guess forfeiture would be appropriate. But again, that's certainly not the case here.
Any other questions? Commissioner Keene.
Sir, when Supervisor Farrell hired Chris Lee, he hired Chris Lee as his committee's campaign consultant. He hired him, right?
As far as I know, yes.
He did.
Yes.
All right. So he's hiring someone as his campaign consultant. His campaign consultant then goes and channels money from another committee that has nothing to, or channels money and channels activities supporting Supervisor Farrell from another committee during the course of the campaign in the amount, total expenditures of $190,000. That's what the FPC has found, that was done by this committee that Chris Lee is coordinating with, that essentially he is the one who's doing it. Supervisor Farrell, whether he's the one who's responsible in the long run for the activities of his campaign consultant, he can't just say, well, I didn't know what he was doing. He's off doing these nefarious things. He's doing these clearly illegal things of funneling illegal campaign contributions to my campaign in the form of all sorts of other activities, but I didn't personally know about it. I'm not responsible. That's not the law, is it?
Well, first of all, with all due respect, I think you're greatly exaggerating what the FPPC found that Chris Lee did.
That's exactly what the FPPC found.
What the FPPC found that Chris Lee did was he sent one email to the committee with a contributor list, which was all public. He sent a second email to the committee with kind of the how to set up a committee, and then he evidently gave the committee the name or, I guess, contact information for a consultant it could hire. So to say that, at least there's no evidence that, and I've read all the summaries of the FPPC interviews, there's no evidence that he funneled money. He gave them a contributor list. He certainly, and there's absolutely no evidence in the record at all that Chris Lee had anything to do, had any knowledge of, or ever saw the mail pieces it put out. It was at the beginning of when this independent expenditure committee was being set up. He gave them a memo about independent expenditure committees in general. He gave them a contributor list, and he gave them a campaign consultant. So first of all, that's what he did. That's a far cry from...
That's not what he did. Let me just stop you right there. On November 20th, 2014, the FPPC approved a stipulation, essentially an agreement, between its staff common sense voters, that was that committee
Right.
that we're talking about, that Chris Lee used to channel money and support to Supervisor Farrell during the election. So that's one of the parties to the stipulation. In addition to those, the common sense voters, the stipulation was also entered into by the vote for Mark Farrell for Supervisor Committee. That's Farrell's supervisor.
I'm going to interrupt you.
Let me finish. And Chris Lee. In effect, that stipulation, which was entered into with the FPC, is a total admission of Chris Lee having done all of these things, and it's an admission that is endorsed by the vote for Mark Farrell's committee. So essentially, we've got a plea of guilty here in that stipulation. But you're saying, well, Supervisor Farrell really didn't have any personal knowledge of it. Therefore, and there's no showing that he had any personal knowledge of it, even though there's no question all of these things happened, the stipulation was entered into, therefore, no harm, no foul.
Commissioner, you're evidently confused by something that confused me also, which is that the stipulation was not entered into or agreed upon by Supervisor Farrell's committee. Vote for Mark Farrell for District 2 Supervisor is part of the name of the Common Sense Voters Committee. The full name of the Common Sense Voters Committee is Common Sense Voters SF 2010, Vote for Mark Farrell for District 2 Supervisor.
It was entered into by Chris Lee.
Right, but I just want to make certain the record shows that
it was entered into by Chris Lee, who was Supervisor Farrell's campaign consultant. So Chris Lee is saying, yes, all of this stuff happened. And Supervisor Farrell is responsible for Chris Lee, and here he is saying, yeah, I did all this stuff, and I did it while working for Supervisor Farrell.
Supervisor Farrell certainly takes full responsibility for the actions of his committee. And
Doesn't
he has
sound
never,
like it.
He has never said or done anything otherwise. He fully cooperated with the FPPC. He has fully cooperated with the Ethics Commission in this matter. And he was interviewed by the FPPC on 2 occasions. We had follow-up phone calls with the FPPC, and they determined that given all the facts, given all the information that they gathered, that it was not that he had done nothing wrong. Yes, his consultant that his committee hired had done, right? Yes, his committee, but did send out those 3 emails that they talk about in their stipulation and that are in the packet of materials that have been provided. So there's no Supervisor Farrell is not quite the opposite, right? To be very frank, he is obviously he was not very happy to find out 3 years later that his consultant had, even though it was only 3 or 4 emails, he was not happy at all to find out that his consultant did it, and then he always took responsibility for that.
I'm sure he was not very happy, and no one is saying in regard to this factual situation that Supervisor Farrell is an evil man, that he's a bad person. None of those things are being said. What's being said here is that the arrangement that was set up clearly violated Section 1.114 of the San Francisco Campaign and Government Code. That is, that Supervisor Farrell's campaign staff consultant worked with this other committee and channeled illegal campaign contributions in the form of money and also ads and hit pieces, all sorts of other things, to help Supervisor Farrell. That is an illegal campaign contribution. That's the one thing that remains left after the McConnell case, after McCutcheon, after Citizens United. The whole idea that contributions can be closely regulated and illegal contributions can be prohibited and punished as they are under this section. That's the only thing that remains to the people in the electoral process to keep the electoral process from becoming corrupt, to keep in terms, and that is policing campaign contributions. If we go ahead and just wave this away, we're essentially, San Francisco, saying, well, it doesn't make any difference. We had this committee that was under the table channeling this illegal campaign contribution activity to Supervisor Farrell, but, he may not have known about it. If he didn't know about it, he's still responsible under the law. And if we don't have that, what we can do is we can have this Pontius Pilate type of thing of everybody washing their hands and say, well, I really didn't know about it. And that's the whole point, that the candidate has to be ultimately responsible in order for this section to have any validity.
Any other questions for Mr. Sutton?
Mr. Sutton, thank you, Mr. Chair. How much do you happen to know how much was spent overall on the whole campaign, on the Mark Farrell campaign?
I apologize. I don't. It might be in some of the documents, John. I don't know if you know.
And I ask because it
was several hundred thousands of dollars.
It was several hundred thousand. So to me, it brings some relevance to this. When you're spending upwards of $190,000 and you end up spending, let's say, all in $500,000, $190,000 is a lot. Obviously, when you're running for president and you spend $1 billion, $190,000 is one small campaign and ad campaign and on local television. So to see that amount of activity and that level of an expenditure within a campaign that probably is somewhere in the mid hundreds of thousands, for me, it is a little hard to believe that a reasonable person wouldn't know about this activity, because that amount of money paid for a lot of things. It's not an insignificant, immaterial amount of money in relationship to the amount of money spent on that campaign in total expenditures.
Well, what I can tell you is what everyone told the FEBC, which is that the people involved with Supervisor Farrell's campaign had no idea of what was being spent until the mail pieces hit them. And I think it was almost all. And John, you correct me if I'm wrong. I think it was almost all mail pieces. That's when they learned about what was going on, and then the committees are required to file reports within 24 hours. So that's when the Supervisor Farrell committee learned what was going on. The other thing is there were also very significant independent expenditures, maybe in the hundreds of thousands of dollars, certainly in the $10,000 spent on the other side. There were independent expenditures spent all over the place. But your question is, with that much money being spent, how could it be reasonable to think that he didn't know about it? Well, he didn't know about it until the mailers were hit the mailboxes. But don't take my word for it. Take the FPPC. They're the ones that conducted the investigation. They're the ones that interviewed everyone involved with the Farrell Committee, everyone involved with the Common Sense Voters Committee, and they're the ones that reached the conclusions that that there was absolutely no knowledge of those mail pieces at all. No one on the Farrell Committee, according to the FPPC, knew anything about the mail pieces. The only connection that had happened were these emails that Mr. Lee evidently sent to the committee at the very, very beginning.
Fair enough, and I still say that if my primary campaign consultant, when I'm meeting with them and I'm deep in the throes of my campaign and it's a hard-fought contest, that they wouldn't be meeting with me and telling me what my activities have been, how far we're reaching with our message, what particular angles we're taking in favor of me and in opposition to my opponent. I don't know. It just seemed, and I understand that there's been a full investigation, but I will. $190,000 is a decent amount of money, and I guess what I'm also not really clear of is once Supervisor Farrell did find out, what action was truly taken then? What action did he take to indemnify himself as fully as he possibly could to make sure that every I was dotted and every T crossed, that this was a reasonable, above-board expenditure, so that we didn't have to find ourselves here?
Well, again, what the FPPC, what he told the FPPC was during the campaign, he certainly instructed everyone working on his campaign to comply with the letter of the law and the spirit of the law. So that's certainly in the record. Then Supervisor Farrell did not, of course, learn what his consultant had done until mid-2012, when he was being interviewed, and those 3 emails that I keep talking about were handed to Supervisor Farrell, and he had never seen them before. And by that point, I'm not certain exactly his committee was closed. Yeah.
Just my last question then. Thank you.
Yeah.
You wouldn't happen to know how many campaign consultants were hired and on staff for this particular campaign?
I don't know, but I do think it's important to note that to be very frank, the Supervisor Farrell that we all know is very different than the candidate Mark Farrell in the spring of 2010. Remember, he was not an elected official. He was not a public figure. He was not the front runner. And so he ran a grassroots campaign. So my understanding is that there might have been some other staffers that were paid whatever they were paid, but Chris Lee was his only true quote unquote consultant. So,
other questions from the commissioners? I have a few, Mr. Sutton. Just to be clear, who specifically are you here representing? Is it Supervisor Farrell and his campaign committee?
Yes.
And so you are not here on behalf of Chris Lee, correct?
No.
And you're not here on behalf of CSV?
Which, of course, begs the question, which we talk about in our letter.
You can just answer my question.
Okay, yes, no.
Okay. And I have read your materials, and I do think you raise some important legal points. But I want to ask one question about something you said earlier. You'd agree that this $500 contribution limit is strict liability. There's no intent requirement, right?
For exceeding it?
Yes.
As a general matter, yes. Yeah.
Okay. So what I'm trying to understand is what additional investigation would be necessary in order to determine that this $500 contribution limit was exceeded. And I want you to set aside, like what I agree are some important legal points relating to statute of limitations and the potential party and interest. But I'm not clear what other investigation needs to be done. I mean, if there was a primarily formed committee that was determined to be within the control of the candidate, I'm not sure why you need to investigate whether or not those contributions exceeded the $500 limit. And I understand that they didn't go directly to the Farrell committee.
Right.
But if they're considered part of his controlled committee, then I just don't know what other facts
I think
necessary.
you misunderstand our point about forfeiture, which is that there are different types of remedies that the commission has the authority to pursue. Most commonly is they can do an administrative fine up to $5,000 per violation. You can also go to court to seek some kind of injunctive relief. You can levy late filing penalties of $10 a day or whatever it is. And you can ask a committee to forfeit money. Our point is that if there's an investigation required to reach the conclusion that a law has been broken, which by definition here, you can't reach the conclusion that the committee received over-the-limit contributions or that there was illegal coordination. You can't reach that without interviewing people, without finding out what happened, without looking at those emails. If it weren't those emails, we wouldn't be here. And because it required an investigation to reach the conclusion that may have been reached, then our point is then forfeiture, is not the appropriate remedy. Then when
because it wasn't known back when it happened in 2010?
Because it couldn't be that you cannot reach the conclusion that the law was violated unless you interview people, look at documents. Forfeiture is only allowed in this relatively limited circumstance where the committees on the reports truly do admit that they've accepted an over-the-limit contribution, or you forfeit money if you don't list the contributor's occupation. So in other words, it doesn't take any investigation. There's a report, and under the box that says occupation employer, it's blank. That's it. But if it requires an investigation, all we're saying is that forfeiture is not requiring. And certainly, our position is not that the Commission doesn't have the authority to act if they believe there's been illegal coordination with the Independent Expenditure Committee. You certainly have the authority to do it, and effectively, your staff was doing it. Your staff not only sat in on several of the interviews, but sat in on the interview with Chris Lee where these emails were revealed. So, again, then, There's a whole, I mean, you guys presumably do it every month where you're looking at proposed stipulations or proposed fines. And that's, if you guys want to pursue the violation of illegal coordination, then you certainly have the authority to do it. It's just that it needs to be done as an administrative penalty, not as a forfeiture. Look at the 100 cases that have been done. All the forfeiture, I mean, most of them are in the tunes of $500, $100, $1,000, $2,000. First of all, they're very small. In every single instance, the committee actually received the money. And this is where it just makes no logical sense. How can you ask a committee to forfeit money that it never received? The whole forfeiture idea comes from criminal law, where the government goes after criminals saying, you bought that car with the proceeds of a drug sale. You have to forfeit that car to the government, right? This money in the bank account came from smuggling, whatever. You have to forfeit those funds. That it is things in the respondent's possession, right, that then they're asked to give up to the government. I mean, it's just a given that neither Supervisor Farrell nor his committee ever had $190,000 in their possession.
Okay, thank you. Any other questions? Public comment? Thank you, Mr. Sutton.
Hello, I'm Larry Bush. I'm speaking only for myself. I would like to urge that the Commission waive any forfeiture in this case. I've looked through the record, and as far as I can see, there has not been a clear definition of what constitutes a controlled committee. In the most part, we know a committee is controlled because someone who files a Form 460 says it is a controlled committee. If they don't say that, this commission in the past has not acted on it. So as I went through the record, I looked at Gavin Newsom's Care Not Cash committee. I looked through his Sit-Lie committee. I looked through his committee on banning city officials from sitting on political parties. I looked at aggressive panhandling. All of them put on the ballot by Mr. Newsom, all campaigned by Mr. Newsom. Not one of them was ever listed as a control committee, and he certainly took a great deal of money from a number of people for those committees, some of which coincided with the same time that he was himself on the ballot. And if you look at the material that was provided by Mr. Farrell's representatives, you'll see the minutes from 2008 of an Ethics Commission discussion that discussed Aaron Peskin's proposal for defining a control committee as being $10,000 or more directed by the official. And the Commission chose not to move forward on that. They didn't put in a definition of what is control committee. As you know, control committees and contributions to city office holders is an issue that Friends of Ethics has been taking a look at. So naturally, my attention was drawn to this particular example. I went back onto the ethics webpage to see, is there a checklist that says, how do you know it's a control committee if you're setting something up? Is it you have the same consultant, that you use the same mail house, you have the same mailing list? And there is no checklist. There is nothing on the webpage itself that outlines how you can tell that it's a control committee. We went through this to some extent with the Run Ed Run committee, in which he was not a declared candidate, so therefore it was not considered to be a campaign committee. It didn't have to file. But that was an unusual circumstance. I think that what you need to do at this point is to waive a penalty in this case and move forward with having a clear definition of what are the check marks that tell you what is a control committee. Thank you.
Members of the Ethics Committee, Ray Hartz, Director, San Francisco Open Government, and this is the list that I showed previously. If you look at the last item on the list, Order of Determination 14105, Ray Hartz versus Mark Farrell, Board of Supervisors. That was failure to respond appropriately to an immediate disclosure request, and Mr. Farrell's explanation was, well, that was my staff. Mr. Farrell seems to have the attitude that if someone on his staff or someone that works for him does something, he's not accountable for it. I have to wonder whether he served in the U.S. military, because in the U.S. military, the first thing you learned is anybody under your command and control who does something wrong, you're answerable for it. And in this case, Mr. Farrell seems to be arguing, and I'll take Commissioner Andrews' question, that $191,000 was spent on material that benefited his campaign, and yet he was totally unaware of it. Just never saw it, never discussed it with anybody, never wondered who this generous person was that was spending all these tens of thousands of dollars to support his campaign, either directly or indirectly. And he didn't ask anybody on his staff, gee, who are these nice people and why are they doing this for me? I find that's kind of ludicrous, to even think of that. But again, we hear the explanation that, well, this was a person, and I'll go back to Commissioner Keene's point. You hire somebody, you're responsible for what they do or fail to do. You're answerable for it, and he failed to take the appropriate measures to ensure this person did not engage in illegal activity, and they went off and did it. And simply then coming back and say, well, because I didn't know he was doing it, I'm not responsible for it, kind of throws the whole responsibility thing on its head. If you hire someone and they do something illegal on your behalf, you're responsible for it and you're accountable for it. Now, the last thing I'm going to say here is something that has become very familiar with me with Supervisor Farrell, which is that he never comes himself to these kinds of hearings. If this was so important to him, why isn't he here to openly and honestly answer the questions that you have, and instead he sends a representative who cannot answer the questions you have? I would say, in my opinion, that it's because he doesn't want to be open in public, on television, being forced to be in a position of answering some of these questions. So he sends a representative to try to give you a song and dance about why he shouldn't be held accountable. And lastly, I'll say this letter from the legal firm in Sacramento answers all of the statements that Mr. Sutton, all the claims Mr. Sutton made. And it does mention, as Commissioner Keene did, the fact that the stipulation was in effect, and basically it's an admission of guilt.
Good evening, Charles Bell. I've been corresponding with you about this most recently today. We believe that you should reject Mr. Farrell's refusal to pay or acknowledge responsibility for or pay for the forfeiture. My letter details this in quite a bit of detail, but I would like to address a few points that were made in argument here. First, with respect to the issue of the FPPC stipulation, Mr. Lee stipulated on behalf of common sense voters that this was a controlled committee of Mark Farrell. Now, Mr. Farrell would not have let him stipulate to that unless he had agreed to it. It is indeed an admission that this phony independent expenditure committee was controlled by Mr. Farrell. And I think that's indisputable and it's of legal significance to this proceeding. With respect to the statute of limitations issue, in fact, your letter of December 9th was within the statute of limitations, as I note here. At the end of January 2011, all of these committees, Mr. Farrell's controlled campaign committee as well as common sense voters, were required to file year-end statements. And on the year-end statement of common sense voters, according to the facts which Mr. Farrell's committee stipulated to with the FPPC, it should have been executed by Mr. Farrell as a controlled committee of Mark Farrell. So the applicable statute of limitations of 4 years, even if it were to apply, would not have run as of the time you sent your letter to Mr. Farrell. Now, with respect to his personal responsibility for this, a candidate is personally responsible for the liabilities of his committees, and Mr. Farrell is responsible for the liabilities of these controlled committees, this one in particular. And there's no escaping that, I think. With respect to the forfeiture policy that has been discussed here, Mr. Sutton is saying to you, well, basically, you can only apply the forfeiture policy to relatively insignificant matters. This is the most significant matter that I'm aware of that's been before you in a long time, basically $200,000 of alleged independent expenditures were actually controlled by Mr. Farrell's campaign consultant and committee. They have stipulated to the fact that this was a controlled committee. They're responsible for this. You shouldn't let them off the hook. The public is entitled to you enforcing your campaign ordinance in this situation where an election really was stolen by this illegal activity. Thank you.
I'm Bob Planthold. I hope nobody feels comfortable with the process and with whatever decision you come up with. Too many people who are attorneys are reading this from the viewpoint of an attorney, but many candidates for office are not attorneys. I'm bringing that up because I think it can be relevant, and I want to try to set up an analogy. If I set up a company, I've got to set up a bookkeeping and accounting system with internal controls. I've also got to have an outside auditor to come in and make sure. So I'm relying upon those accountants' professional knowledge and skill and adherence to their duties. I'm running the company. They're supposed to handle that part of their world. I'm suggesting that a candidate who's not an attorney pick somebody who's ostensibly reliable. We know others that were or are. P.J. Johnson ran Willie Brown's re-election campaign. Jim Stearns ran it. If you hire them, you figure they have a track record. They know what they're doing. They're supposed to do their job and know their job. Meanwhile, I'm, in this case, a candidate. I'm running, speaking. So it may be that there was a misplaced trust by Farrell. And I'm not saying he did a good job in this. He was lax, if not negligent. But if he relied upon the professionalism of somebody who failed to do their job, that may be a problem not only for him. I want to turn it back on you folks. It may be you should look at the trainings and the information you give to candidates. Maybe you need to develop something that when a candidate files, you make sure the candidate gets something that says, candidate, make sure your campaign staff don't do this, don't do this, don't do that. A bright line of a list of don'ts may be worth keeping in mind for the future. This may be a learning experience. I think nobody's going to be satisfied whatever you decide. But you may want to move forward and say, making clear to candidates, because they're not all attorneys, that candidates have to monitor their own staff and not just be the candidate out there speaking, hustling, persuading, and that's, I think, the candidate's job. So keep this in mind. You may have some additional work for ethics to do in the future to preclude, to prevent, to lessen the chances of something like this happening. Thank you.
So my understanding is that under commission policy, the staff is the entity that would seek the waiver from the commission were they to deem that appropriate. Staff has not requested a waiver as far as I'm aware. That typically the entity from which a forfeiture is sought will talk to staff, and if staff agrees that a waiver should be sought, staff will then bring that to the commission. I found, does anybody, Mr. St. Croix, is that accurate? City Attorney, Mr. Shen, do you want to weigh in on that?
I'm sorry. So the process is that if the staff believes a forfeiture is appropriate, that they would bring the waiver to the commission?
No, if the staff is seeking the forfeiture as of now. If the staff deems that a waiver is appropriate, that they would request to the commission that the waiver be entered.
If it's over $500.
If it's over $500. Is that accurate?
I certainly would defer to the executive director on this, but I believe there's been other waivers in the past that have not been presented to the commission.
Right, but the distinction I'm trying to make is that typically the entity from whom the forfeiture is sought is not seeking the waiver directly from the commission. That it's that staff sort of signs off on it before it's ultimately brought. And I understand this was an unusual situation because we invited Supervisor Farrell's representative to come explain this to us and submit their response letter, but that typically we don't entertain a waiver directly from the entity from whom the forfeiture is sought.
Right, I believe that's correct. In my experience, most of these forfeitures have been dealt with at the staff level. I was just slightly thrown off by the reference to bringing those matters to the commission. I'm not aware of any waiver requests making it to the commission on a forfeiture issue, but I could be mistaken. I'll defer to the director on that.
Sorry, go ahead, Mr. St. Croix. What were you going to say?
Is this working? I don't recall that we've had any that we've brought to the commission in the past.
I see. Okay. So it's something that could be brought to the commission, but typically is not brought to the commission. Okay. Sure. You can come to the podium.
As this process has been explained to us, is that this is a staff generated and that staff has the final decision-making authority. Certainly, the commissioners have the right to ask someone to come in to talk about the matter and to make recommendations to the staff, make suggestions to the staff. But this is not a request to the commission because that's not what we were told we were supposed to be doing here. The request is to Mr. St. Croix, and the commission is taking this opportunity to give him suggestions.
Correct. That's my understanding as well.
Okay, thank you.
Okay, so thank Mr. Sutton and the public, Mr. Bell, for coming in and providing further information for us on this. I think it was helpful for all involved. Anything further from the commissioners on this? The next item on the agenda is discussion and possible action on the selection of random audits of lobbyists and committees that were active in 2014.
Hello, good evening. This is Shaista Sheikh, Assistant Deputy Director. And before we proceed to the audit selection, I just want to summarize what we did in the past year. In order to eliminate the backlog of audits, staff requested the Controller's Office's assistance in conducting audits. The Controller's Office conducted 13 audits, and staff conducted the remaining 27. Work on all of these audits has been completed, and most of them have been finalized. Staff is currently working on finalizing 4 of its audits and the 13 that the Controller's Office did. Staff expects that these audits will be finalized within the next few weeks, and thus, after today's audit selection, staff can begin work on the audits that will be selected today. And as explained in the audit memo, we recommend that the Commission select 10 campaign committees for audit and 4 lobbyist firms for audit. The memo contains 2 charts that show how staff divided the audit pools into 3 levels of financial activity. The charts also show staff's proposal in terms of the numbers of committees to be selected from each level. Do you have any questions about the proposals?
Questions from the commissioners? I have a couple questions.
Sure.
So, I know that Ms. Sheikh, you and your staff, they spend a lot of time on these audits. Mm-hmm. Can you give us a sense of how many hours are spent on an individual audit on average?
We don't currently track hours, but this is something that we're looking into to see whether it would be efficient and productive for us to do. But currently, we do not track hours.
Can you give me a ballpark?
We estimate that each audit should take about 3 weeks.
Okay. 3 weeks at 40 hours a week, approximately?
Yes, but we overlap audits. So when auditors are not working on just one audit at a time. Mm-hmm. Also, our auditors serve other functions. For example, one of our auditors serves as the Commission's budget officer.
Okay. So, okay. If an audit takes about 3 weeks, mm-hmm. and you're going to do 10, you're talking about 30 weeks of work, approximately?
Approximately, yeah. And some audits may require longer time depending on the complexity or problems that may arise.
How come we can't do a few more if we have staff and you're only talking about 30 weeks of work?
So we also would like to build in time to train the auditors on the lobbyist program, because the auditors have never conducted lobbyist audits. So we'd like them to become familiar with all the rules that lobbyists have to comply with, and so that they can effectively audit the lobbyists. We'd also like to ensure that we don't become backlogged again. So before we come back next year for the next audit selection, we want to be able to say we've completed all the audits. So our goal is to complete audits in a timely manner. And we also want to step back to review our audit processes to make sure that we're doing our audits in the most effective manner.
Okay. I think it would be helpful for in this cycle for you guys to track how long it's taking, so we can get a sense of how much effort is required. Thank you. Any other questions for Ms. Sheikh? Okay. Public comment.
I'm Bob Planthold. I wanted to applaud and second the idea of trying to keep track of the amount of time. But I also want to draw upon my own experience. I think, considering you have a later item about a work plan, I think individual commissioners ought to consider trying to find a way to communicate to the supervisors how much work still is undone or needs to be done. When you look at the chart and the randomness, it's quite possible some of the categories that have a significant number of committees could be unaudited because of the limited number of audits in the random process. I'm suggesting, again, there may be a basis for you folks to start laying the groundwork, at least for next year, during the add-back process, if the mayor himself doesn't put in money for additional staff, that the supervisors, knowing there is a need, may generate that. That's what I engineered when I was chair. I fought and got 1/2 extra staff during Willie Brown's term, and that was a lot of work to do. You do need more staff, many of us believe. And while the mayor initially proposes the budget, the soups through the add-back process can increase. That's not always easy when there's many other competing needs. But if you can start to show how much time it takes and how few committees actually are audited, and develop a statistical analysis of how likely it is that some major clusters of committees might be overlooked in a random process. That requires some statistical analysis, but you can see some major committee groups could be totally ignored. That's a reason to say you ought to have more staff, along with other reasons for other staff. Thank you.
Commissioners Ray Hartz, Director, San Francisco Open Government, and I have to apologize. I'm not as prepared as I would have liked to have been, despite the fact that in January I sent in a request to be retained on the interested persons list. I have stopped getting the agendas packages for this meeting. I have to wonder why that is. The Library Commission started to do that too. Be that as it may, I have a real question as to somebody I feel should be on this list for an audit, and that would be the Friends of the San Francisco Public Library. This group engages in lobbying activities. They provide $30,000 a year to the city librarian for public relations. They raise money in the name of the San Francisco Public Library and the citizens of the city. In fact, between 2001 and this current year, they have expended over $70 million raised in the name of the citizens of the San Francisco and its public library. And yet, most of those cases that I showed you earlier today had to do with me trying to get information from the library or the Library Commission about why they continue to approve this group and their activities without any information as to where the money goes. They cannot account for approximately 95% of that $70 million. The Friends report to a private charity group that they expend more than $6 million a year, and yet what they give to the library is a thing approved by the Board of Supervisors for $375,000. That's approximately 5% of what they raise. They spend more on their own operation than they actually raise on behalf of the library. Why aren't they on here? I mean, obviously, 19 cases I've won, most of them having to do in some way, shape, manner, or form with the Friends and the $70 million and more that they raised in the name of our public library with the approval and acquiescence of both the Library Commission and the city librarian, and yet these public records show that these folks don't know where the money went. So if you're going to put a group on the list like the San Francisco Chamber of Commerce, who I have a funny feeling probably does everything by the book, why aren't you putting a private group like the Friends of the San Francisco Public Library on here when they have obviously, from everything I have found, not done it? Now, we'll add to this, and this brings the FPPC. The FPPC found that city librarian Luis Herrera, for 3 consecutive years, despite being a city department head, accepted over $5,000 worth of items he was required by law to report, and then filed each of those years under penalty of perjury a statement that he received nothing. So now you have a city department head engaged in an illegal activity with a group. I think they should be on here.
Hello, Larry Bush. I would also second the question about whether or not this list is complete of people who've been participating in elections at a level that would warrant being audited. I gather this list is made up of those groups that actually filed that they were a political committee. He's just pointed out Friends of the Library as a group that has not filed as a committee. I think the same thing is true of Parks Alliance, which put quite a bit of money in the last election into the parks measure, but they also do not file. So I wonder if in part of this process you might want to delay this and ask for a more detailed review of campaign expenditures by organization and not just by those committees that are listed. Thank you.
Ms. Shea, can you respond to that? I mean, are there missing entities here? Are we sure we have everyone?
The memo does state that we exclude entities that raise less than $10,000, and we base that on prior guidance from the Commission on focusing on entities with higher levels of activity.
Okay, but understanding that exclusion of the others, are we confident we have everybody?
Yes.
Is there a motion to select the...
I don't think we need
We don't need a motion?
No.
Okay.
Just need volunteers from the...
So we have in a box the names of each of the committees for each category. And so we need a couple volunteers from the public to read them off and ensure we have everybody, and then to select from the box those lucky entities who will be audited.
Do you think the former ethics commissioner is reliable?
Mr. Planthold, I think so.
To have him roll up his sleeves first.
I comply.
The group in which entities raised or spent more than $100,000. So, Mr. Planthold? Here are the chits. If you could read them one by one, and as you read them, hand them off to us so that we can fold them and put them in this box.
No on E, Stop Unfair Beverage Taxes Coalition for an Affordable City. Should I read all of what's in type, or is that an adequate definition?
That's adequate because the members of the public and the commissioners have a list here that they can follow.
Yes on F, with major support from. Stop the housing tax, no on G. Committee for Reliable Transportation and Better, Safer Streets, yes on A. Let SF Kids Play, yes on I, no on H. Children and Family First Committee, yes on C. Committee for Better Wages, yes on J. Oops. Yes on C. San Franciscans for a Safe and Affordable City. Multiple major funders. Yes on E. Choose Health SF. San Franciscans Against Real Estate Speculation, a committee for Proposition G. San Franciscans for Fire, Earthquake, and Disaster Preparedness, yes on A. No Wall on the Waterfront, yes on B. No on B, 2014. Campaign for a Fair Economy and Higher Wages, yes on J. Coalition for Affordable Housing, a committee for Proposition K. Committee for a Brighter San Francisco Future, supporting Props A, C, I, J, and K, and opposing Prop G. Restore Transportation Balance, a committee in support of Proposition L. Re-elect Malia Cohen for Supervisor 2014. Re-elect Supervisor Mark Farrell 2014. Jane Kim for Supervisor 2014. Re-elect Supervisor Scott Wiener 2014. Rodrigo Santos for San Francisco Community College Board 2014. Carmen Chu for Assessor Recorder 2014. San Francisco Alliance for Jobs and Sustainable Growth PAC. San Francisco Police Officers Association Issues PAC. Unite Here Local 2 PAC. Building Owners and Managers Association of San Francisco Political Action Committee. Independent Expenditures. San Francisco Labor Council Labor and Neighbor PAC. Alice B. Toklas Lesbian and Gay Democratic Club PAC. Mayor Ed Lee for San Francisco Committee. That's the last slip provided me.
Okay. That's it for. They use their own money. Yeah, that's it. Okay. So those are all the committees in activity level 1, and we are to select 6 committees from this level. Would someone like to come up and select that for us?
One at a time?
Yes, one at a time. Would you like to read it for us?
Yes. Mayor Ed Lee, Mayor Ed Lee for San Francisco Committee. Committee for Better Wages, yes on J. No on B, 2014, sponsored by San Francisco Alliance for Jobs and Sustainable Growth. No wall on the waterfront, yes on Prop B. Jane Kim for Supervisor, 2014. Yes on E, choose Health San Francisco.
How many is that?
6, I think. Hold on a second. We have 6.
Oh, okay.
6. Great, thank you. Would you like to read the names of the next audit poll? A whole new set of slips. Yes. Okay, so this is the second level of activity.
Okay. Okay. Coalition to Protect Golden Gate Park. Adjournment Mendoza for School Board 2014. Shannon Walton for School Board 2014. Katie Tang for Supervisor 2014. Committee to elect Stephen Cook for School Board 2014. Carballo for District 2 Supervisor 2014. Committee to elect Emily Marais for School Board 2014. Committee for Jobs Government Reform Fund. San Francisco Labor Council, Labor and Neighbor Independent Expenditure Political PAC. National Union of Healthcare Workers Candidate Committee for Quality Patient Care and Union Democracy.
We need to select 2 committees from this level.
Okay. So.
Would you like to read it?
Okay. Hydra Mendoza for School Board 2014.
One more. Just put it in the same.
Carballo for District 2 Supervisor 2014.
Thank you. And we have one more audit poll of campaign committees. Would you be kind to read those?
So this is the third and last pool. Okay. No on L, San Franciscans Against Gridlock. Yes on J and G, Chinese Progressive Association. Committee to pass Laura's Law 2014. Mark Murphy for School Board 2014. Lee Su for Board of Education. Committee to elect Tia Selby for San Francisco Community College Board 2014. Re-elect Public Defender Jeff Adachi 2014. Ed Donaldson for District 10 Supervisor 2014. John Rizzo for Community College Board 2014. Golden Gate Restaurant Association PAC. San Francisco Forward, sponsored by San Francisco Chamber of Commerce. Transport Workers Local Union 250A COPE Fund. SF Moderates. San Francisco Young Democrats. FDR Democratic Club of San Francisco. Asian Pacific Democratic Club Political Action Committee. Residential Builders Association of San Francisco, PAC. San Francisco Parent Political Action Committee. District 11 Democratic Club. I have no more slips.
Okay, thank you. Will you select 2 from this batch?
Why not? Let's tag team back and forth. So I don't pick what I.
Yeah. I'm Bob Dockendorf. I was commissioner 96 to 2000.
Okay, 2.
District 11 Democratic Club. San Francisco Young Democrats.
Thank you. So that's it for the campaign committees. Now we'll move on to the lobbyists. So, similarly, the lobbyists are divided into 3 levels of activity, and we will select committees from these 3 levels. 2 from the highest level, and 1 each from the next 2 levels. Again, we need volunteers.
San Francisco Chamber of Commerce. Reuben, Julius, and Rose, LLP. Appoint and Associates. Platinum Advisors. Goodyear, Peterson, Hayward, and Associates. SFAA. BMWL and Partners, Inc. HMS Associates.
Okay. So we need a volunteer to select 2 from this group.
LaPointe and Associates. San Francisco Chamber of Commerce.
Thank you. Will you read the next level?
So for this Pacific Gas and Electric Company, Committee on Jobs, Building Owners and Managers Association of San Francisco, Berg Davis Public Affairs, Hanson Bridget LLP, Ground Floor Public Affairs, Louis Leuven, Coalition for Better Housing, Public Advocacy Partners.
Okay. Please select 1 from this group.
Hanson Bridget, LLP.
Okay. The last level.
Okay. Michael Yaki. Andrew Gregg. Airbnb. Barbary Coast Consulting. Karen Flood. Bay Bio. Trust Company of the West. Edward Day. TZK Broadway LLC. Tishman's Speyer Properties LLP. Fortress Capital Formation LLC. SGC Strategic Communications. Cisco Systems Inc. Philip Lesser. Farrell, Braun, and Mattel. Willie Brown. James Ross. Fong La. Daniler Consulting, Inc., and John Newman.
Thank you. Select one.
Just one?
Yes.
Okay. Airbnb.
Okay. Great, thanks. That completes our selection process.
Thank you, Ms. Shake, and to the public for your assistance. 2 former commissioners. Can't get better than that. The next item on the agenda is discussion and possible action regarding the proposed project calendar for various staff projects. Mr. Minardi, are you going to introduce that one?
Yes, Commissioner Herr and Commissioners, thank you. Jesse Minardi, Deputy Director. Commissioners, at the last meeting, the Commission approved 4 proposals for staff to pursue and investigate in terms of augmenting the city's campaign finance reform ordinance. And given sort of the choices and sort of the amount of work involved, the Commission directed us to prepare a project calendar that essentially estimated sort of how much time and the type of work that might go into each particular project, and then to bring that forward to the Commission for comment, approval, and certainly suggestions, and ultimately direction as to your thoughts as to that calendar. Along the way, also, the Commission did ask us to start moving on one particular proposal, which was the proposal regarding candidate-controlled ballot measure and general purpose committees, and applying limits and prohibitions for candidates to those committees. We did do the language. We reached out to a few folks to get feedback. We identified one issue, which I'll talk about a little bit later, for your approval, but ultimately just getting started. So in developing this calendar, though, one thing that I thought would be helpful, though, is that there are, through a variety of ways, a lot of sort of other outstanding issues out there. And I thought we thought that it would be good for the commission to see all of those issues and then make its decision based on that full information, receive input from the public with respect to all of those, just so everybody's sort of on the same page as to what's out there, approximately how long things are going to take, when the work we'd be trying to get it done by. So what we did was we added the additional issues that we are aware of. We put it in to the memo. And so we, number one, try to lay out what those issues, additional issues are, and then give an estimate about how long each one might take. We talked with the city attorney's office, particularly with respect to sort of building a record as to the candidate-controlled committee issue. And then we tried to figure out, well, what is the most important and how would we prioritize these? And a lot of this was sort of us trying to take the cue from the commission, but also kind of looking at what we see are issues and putting it in there. So it's a mix, probably not perfect, and I'm sure you folks will have thoughts on that, but this was our best guess. So the way the memo is set up is just sort of running through the various issues, running through how long it might take, and then we have this proposed prioritization, which again on page 7 is our sense based on the commission's direction and our understanding. Then we do have this contribution limits language, but then at the end is this calendar which gives a sense of sort of where everything in gray is where staff will be working on a particular issue. And then anytime it says sort of meeting is the intent is that the commission would actually decide on something or hear something at that point. So just running through very briefly, it's all sort of in the memo, but we essentially had the 4 issues that the commission voted on last time, which was the candidate-controlled committee limits and prohibitions, the bundling and fundraising reporting, the prohibitions triggered by the receipt of public benefits, that's sort of the Prop J issues, and then the slate mailer filings, getting those filed with the Ethics Commission as opposed to the Department of Elections. So then we identified a few more issues which we broke up in a few ways. The first were sort of procedural issues, and the 2 that we identified were sort of enforcement policies and regulations, addressing some of the regs, some of the procedures, doing some streamline enforcement revisions, maybe some form stipulations for minor violations, that sort of thing. The second thing under these procedural issues is the forfeiture and late fine policies. This goes back to this August 2008 staff memorandum that outlines the relevant procedures, and Commissioner Keene had asked way back for a review and perhaps improvement on that memo. So we want to do that. Then we have 2 outstanding issues from the civil grand jury. One is sort of a revisiting of the expenditure lobbyist reporting requirement. In its response to the civil grand jury, the commission said that you would look at the issue as a general matter to decide if you wanted to move forward. So that is still outstanding. And then there was also recommendations with respect to additional reporting of gifts of travel. So those are 2 issues there. And then the final set of issues really has to just deal with ongoing sort of reporting issues that we feel the commission has to deal with. One is the move to all electronic filing for Form 700 filers. This would go beyond sort of the department heads and elected officials who currently file electronically now and go to all city filers, employees as well. And then finally, the permit consultants. Permit consultants will be filing their first quarterly report on April 15th. We've had a lot of sort of questions. We've been kind of holding off the idea of doing regs until we kind of see how the first quarter or 2 goes. But that is ultimately something we want to do. Initially, it was staff's intention after the initial CFRO consideration in January that we would move to the two outstanding civil grand jury issues and then go to enforcement and forfeiture issues at that point. But obviously, from that conversation, we kind of got into expanding the scope of what we might do with CFRO, which is why we haven't addressed those yet. So as you'll see, and then I'll wrap it up, we've, on page 7, identified what we see as the higher priority issues, which are the candidate control committee limits based on our last conversation, enforcement regs and policies, this Form 700 electronic filing issue, the bundling and fundraising reporting, and then perhaps any additional reporting for gifts of travel. And then the rest, while certainly important, we would consider of lower priority. And so as a result, we created our chart there at the end, which essentially says that we would do the Form 700 and Candidate Control Committee issues basically through September. Number one, with the Candidate Control Committees would involve a lot of work in terms of building the appropriate record, and then go to the bundling reporting as well as beginning the enforcement regulation and policy discussion. So that's the summary, and happy to answer any questions or take any comments.
Questions for Mr. Minardi or the staff?
Just a comment, I think you've done a good job synthesizing and prioritizing our past discussions and also adding the things that you did.
Thank you.
I guess just for information purposes, on your memo on page 3, you sort of list bullet points of what has to be done to get to the end of the candidate controlled committee regulation. And that looks like a very extensive amount of work. And can you give me some idea of how you would implement it with the staff? I mean, how many staff people are going to have to be involved? And what kind of hours do you think are going to be spent on it?
Well, I think you're looking at them, but in addition to that, obviously we would work with the city attorney's office. We would probably work with our IT director, Stephen Massey, to a considerable extent. Some of it is going to be, reviewing contributions that were made to the various committees. I think our first our first step, which we've already started to do, is make sure that we have a full handle on the law. We've seen some of the literature out there because there are some, law review articles, right, that sort of thing. Reaching out to some of these former elected officials who have actually controlled ballot measure committees, getting their input and hopefully asking them to come talk. And then, to the extent we can get somebody who's an expert to come in here, we're going to want that. So a lot of it is setting up that sort of first big meeting so that the commission can consider all that testimony, whether oral or written, and then obviously doing the IP meeting. So I realize all I'm doing is describing the process as opposed to maybe really.
The question I have now, for example, the legal research that the city attorney's office presumably will do for you unless they can get some pro bono help somewhere who's willing to help the city. That would apply, though, to a number of these, would it not? Not just to the controlled committee, but to a number of the other ones. And how about the public, sort of the public hearings? Would it make sense to try and combine them so that you're making the record not only for, say, the candidate-controlled committees regulations, but other regulations that you've got on that priority list? Well, is that doable, do you think?
I guess I would be hesitant to do it, with respect to the reporting issues. a lot of time, I think what we want is feedback in terms of what would be most valuable to the public, how compliance would work with the regulated community, that sort of thing. But with this really, and also with the the Prop J stuff, when we're really talking about some important constitutional issues,
Right.
I would just be worried about sort of giving them short shrift and if everything was kind of combined together.
Any other questions or comments from the commissioners? I echo Commissioner Keene's statement. I think this was well done and very helpful for synthesizing where we need to go. One suggestion that I have is I know we don't have any formal committees on this commission, but to the extent commissioners want to participate on any of these, I think hopefully that would be welcomed by the staff.
Without a doubt.
I, for example, have these enforcement regulations have been near and dear to my heart, as you know, in working on those. So I'd be happy to help on that. And to the extent other commissioners want to work on some others, maybe you can reach out to them, or they can reach out to you as they see fit.
Great.
Public comment.
Hello, I'm Larry Bush, and this time I'm speaking on behalf of Friends of Ethics. We did send a letter to each member of the commission outlining a number of concerns that we had. Looking over this, I just want to add a postscript to that. On the calendar, I think it would be helpful to the commission if, in addition to the timeline of activity for the staff and the commission, you also included in here the timeline for political activity that will be going on in the city at the same time. So sometimes you'll be seeing campaign finance reports will be coming in. That will help educate the whole process. And if you just included that in June and then in August and September and November there is an election, I think that's an important part of looking at your calendar. Secondly, on the issue of travel and more disclosure, I think that the civil grand jury request was also for behest payments and not just travel, because it's another way in which people have an ability to respond to City Hall interest by writing a check to someone that City Hall wants to see funded, and in some cases, their own offices. And then I think that on terms of the control committee, the first step I don't see listed here, which I think is to define how do you know that a committee is a control committee. We really still don't have a good checklist. It's the same thing that was raised in the August 2008 minutes. Is it that you have the same consultant? Is it that you have the same mailing list? Are you sharing donor lists back and forth? How do you know that it's a control committee? And I think that that's important for the political process to be known. It's not just a short thing. A lot of the other types of issues that you're looking at, like legal research, it's going to be very instructive to see what other ethics commissions and jurisdictions responsible for ethics enforcement are taking a look at. We have done that through Friends of Ethics. We did a little bit on civil grand jury. We'll be happy to provide you all with the results of all of that. Lastly, some of the reports that you'll be looking at on your sites, like, for example, which are the control committees, are obviously incomplete. You have to go back to, I think, 2007, when the Ethics Commission first decided to take a look at what was going on with control committees. And that's when this August 2008 thing took place. Prior to that, there really were very few that were ever listed as a control committee. Even if it's put on the ballot by the mayor or by a supervisor who went out and campaigned for it, had the same campaign manager and all the rest of it, it's not showing up as a control committee. So while you may be asking for some former elected officials to come and talk about how they had a control committee, you might ask some other former officials to come and talk about why they didn't think that it was a control committee. I have names.
Commissioners Ray Hartz, Director, San Francisco Open Government. The comment I have to make on this is there seems to be some sort of a belief amongst the commissioners that the only thing you're concerned about is campaign finance. Everything else that you're responsible for can go by the board, because everything here seems to be related to campaign finance and nothing else. I would like to look at a couple of these items, like higher priority, enforcement of regulations and policies. How about the Sunshine Ordinance? We see this on the screen? Okay. I hope I don't get stopped exactly at 3 minutes, because that was done. Very frankly, I've been dealing with the Sunshine Task Force for the last 8 years, and I've heard nothing but excuses from this commission as to why you can't enforce the law, even though the law clearly states that the Ethics Commission is responsible for enforcing it. You don't do anything about it. You don't make it a project. It's obviously not a high priority. In fact, I don't think it has a priority. Why? Because you would have to enforce it against people that you work with, fellow commissioners on other commissions and boards, or members of elected office. And we saw what happened when you recommended to the mayor that Jewel Gomez be removed from the Library Commission. The mayor just ignored you. And a year later, you sent him another letter. He didn't even respond to that. I think you're just avoiding talking about certain issues because you know you can't do anything, and it makes you look bad when you're proven not to be able to do anything. And here I have, as an individual, 19 cases where city representatives have violated my right to free speech or my access to public records, and you don't seem to give a damn about it. In fact, Mr. St. Croix, your executive director, does his level best to find some technical reason to dismiss every single one, and failing that, holds the hearings while I'm out of the state. And you say, well, Mr. Hartz is like a broken record. You keep going over and over. I have a question for you. Would any of you, having gone through 19 hearings before the Sunshine Task Force and won them, not be a little perturbed by the fact that the body that's supposed to enforce them won't get off its backside and do a damn thing to even try? People think this is a liberal bastion of, I go to the American Legion in Florida because I'm a member of the Legion, and every time they say San Francisco, they go, oh, liberals, liberals, liberals. I think they would be really shocked to realize that First Amendment free speech rights, especially as directed to political free speech, are not respected here in San Francisco at all. Just last Thursday at a Library Commission meeting, I was interrupted in my public comment once again, and we're going back to the task force once again. And still, you do nothing. Nothing at all. And I'm not the only citizen who has these. There are a lot of them out there, all wondering why bother to go to the task force when you're going to roadblock whatever they do.
Mr. Minardi, one other suggestion I had on the calendar was that we keep it kind of live, meaning that it be a running calendar, and you could sort of, to the extent we make decisions about things that need to be added, that you guys would sort of keep it up to date, because I think that will be really helpful for all of us understanding where things are.
Yeah, that's great. And as we put in the memo, I think the intention is to check in, every few months, just so, because, things happen, obviously, and we want to keep everybody abreast of what we're doing. So that's a great idea.
Thank you. The next item on the agenda is election of officers, discussion and possible action regarding the election of a chair and vice chair to serve for the coming year.
Before we go to that, what was there was also the draft language that had been submitted.
Sure. And there is the draft language, which is pretty straightforward. I don't think the commission has to make a decision right now, although certainly if you want, we would explore a variety of options. The one thing we just wanted to highlight is that the discussion to this point has been about limiting or prohibiting contributions to ballot measure committees and or general purpose committees. But there are actually two separate different types of committees that a candidate can control. One is One is a committee for election to the Central Committee, the Democratic Party here in San Francisco. That we are prohibited by express provision in state law from putting any limits on. So we can't do that. But the other sort of set are these legal defense funds, which are essentially funds that are opened by a candidate when he or she is facing potential legal action in connection with their running for office or the performance of a duty while in office. And currently, those also are there's no limit on them either. So the decision would be whether we would move those, expand those prohibitions and restrictions to also cover those committees as well. We are only aware of one committee that's ever been a legal defense fund that's ever been opened. But other than that, presumably the same rationale may or may not apply. The same rationale would apply, but there are obviously considerations as to whether the commission thinks that as a policy matter, it doesn't want to impose those limits or restrictions.
But what reasons would there be to not include the legal defense fund?
And this is speaking sort of hypothetically. One reason perhaps could be that running for office is you can set yourself up. You're a very public person, and in a political sphere, people use a lot of means to try to attack you, including potentially litigation. And if you're limited in your ability to if you don't have money yourself, let's say, and you then are limited in your ability to sort of raise funds to mount a credible defense, that might discourage people from running from office, that sort of thing. So that's one of the things you might think about.
Commissioner Rennie, did you want to vote on this today?
No, I mean, I gather that it probably makes more sense to be further down the road in our analysis. Sure. For example, the question that was raised by Mr. Bush, if a committee for a proposition and one of the candidates is very active in it, does that make it that candidate's controlled committee, even though ostensibly it's set up not under his or her direction? I think those questions probably should be spelled out a little bit.
Do you want to talk? Yeah.
So and I know we're going to have plenty of other hearings and discussions on this general topic, but just on the issue of what constitutes a controlled committee. So local law already incorporates the state law definition of what is a controlled committee. So there is a provision of the Political Reform Act that defines what a controlled committee is. In addition to that, the FPPC has issued many different advice letters analyzing what constitutes a candidate-controlled committee. So there is already existing guidance on that question, and it's something that I think we would follow here locally in San Francisco. But again, we can certainly talk about that later.
Thank you. Anything else on agenda item 5? Okay, the next item on the agenda is election of officers.
In commissions, we traditionally choose a chair first and then a vice chair. Once the chair opens the floor for nominations, any commissioner may nominate another commissioner, or a commissioner may nominate his or herself. Nominations do not require a second.
Okay. Let me start by thanking my fellow commissioners for allowing me to serve as chair this past year and for 3 terms, actually, over the course of my time here. And very much appreciate the staff for all their hard work and effort, and for the public in indulging me as well. Look forward to new leadership on the commission. With that, can I open it up for nominations for chair for this coming year? Commissioner Keene.
Yes, Mr. Chair. In light of the fact that you do not want to be renominated for chair, I would nominate Commissioner Rennie for chair.
Any other nominations for chair? Okay, hearing none. Public comment? Public comment?
Commissioners, Ray Hartz, Director, San Francisco Open Government. We need somebody on this commission as its lead who will actually lead. And I don't mean just campaign finance, because campaign finance basically is rearranging deck chairs on the Titanic. Every time you try to find one way of stopping people from illegally using money to influence campaigns, they have 10 other people hired to find a way around what you're doing. I would like somebody who is actually going to make an effort to do some of the things you're supposed to be doing and have neglected doing under the current leadership, such as enforcing the Sunshine Ordinance. I think most people in this city really think that they have the right to go to a public meeting and make public comment until the shit hits the fan and they go and try to say something that isn't appreciated and they're told they're not allowed to. I've got a list of 19. Or they try to get public records, which they need to make effective public comment, and they're denied those by people who know under the law they have a requirement to provide it. And yet for 8 years, I've been coming to these meetings, and I keep hearing a bunch of lip service to your responsibility of enforcing the Sunshine Ordinance. Like on tonight's agenda, there's an item there, and there's one case from the Sunshine Task Force. I think they've gotten to the point where they don't see any sense in referring it to you because they know you're not going to do anything with it. And again, purposely to protect other people in positions of authority here in the city of San Francisco. Those 19 cases that I won were individuals who knew their responsibility under the law and just decided, like Luis Herrera, the city librarian, he didn't want it exposed that he was taking thousands of dollars of gifts from the friends and then lying about it when he filed his annual statement of economic interest. And I use the word lying because that's what he did. It was penalty of perjury. He signed a statement saying, I got nothing. And it was thousands of dollars of travel and hotel expenses and other things that he took. And when I tried to get the public records, he held them for 2 years. He got the city attorney's office involved because they wouldn't go forward and make him give the records up. So they were found in violation of the ordinance. I would like to see somebody run this commission who actually wants to do more than just playing around with campaign finance. You have a responsibility to enforce the Sunshine Ordinance, and I have not yet heard one member of this commission deny that fact. It's a responsibility under the law. It's a law that the majority of the citizens of San Francisco passed, and I think the majority of the citizens would question why you think campaign finance is going to be effective when you can't even get people to release public records so that they can look into the way city money is being handled and or mishandled. If citizens don't have a right to know, everything else goes by the way. And Mr. Rennie hasn't shown any leadership in this area any more than Mr. Herr.
Hello, Larry Bush. I'd just like to make 2 points. One is that many of you are new in terms of last year or two. Commissioner Rennie is one of the few commissioners who I've seen attend an interested persons meeting to hear what people had to say. That was very much appreciated. As rare as it was certainly appreciated that he came. And the second thing is that the commission has been taking some steps forward with this new, I don't know what you call it, a dashboard, something that allows people to take a closer look at how money is coming into City Hall. And I think that speaks well for where you will be going next. And I know that Commissioner Rennie was one of the commissioners who raised the issue of expenditure lobbyists before. And he was disappointed that I wasn't able to come and talk at that time, but I was just onto the civil grand jury, and I took a vow of silence. I know you'd like me to be back on again, but I'm not. Thank you.
Okay, is there a motion to elect Commissioner Rennie as chair for the coming?
Second.
All in favor? Aye. Opposed? Hearing none, that motion passes 5-0. Congratulations, Commissioner Rennie. Next is the election of a vice chair. Are there nominations for vice chair? Commissioner Keene?
Yes, I'd like to nominate Commissioner Andrews.
Are there any other nominations for vice chair? Public comment?
Commissioners Ray Hartz, Director, San Francisco Open Government. And I'd like to say that I am very much in favor of Commissioner Andrews serving as the vice chair of this commission. And the reason I say that is because I have gone through several times and looked at the video of the hearing that was held on my matter referred by the Sunshine Ordinance Task Force. And the only two people who asked any serious questions were Commissioners Keene and Commissioner Andrews. One of the questions Commissioner Andrews asked the city librarian is, did you make any effort to see if there was some way of letting Mr. Hartz use the audiovisual equipment without expending $40,000 to do so? And of course, the city librarian stood right here, looked in his eye, and lied to him. There's no other way. All he had to do was take the PowerPoint slides that I mailed to them, and they got, and I know they got it because they made copies and put it in the back of the room, and include it just like they do the other groups of private individuals like the Friends of the San Francisco Public Library. It's not Commissioner Andrews' fault that I guess he did what most people do. He listened to somebody in a department head's position with city librarian and assumed that he wouldn't lie, especially not on television. But he did, and I can say that without fear of contradiction because it was proven. Okay? Commissioner Andrews has shown on several occasions to be willing to ask questions that really do need to be asked. I would have been very comfortable also with Commissioner Keene, because Commissioner Keene is a very great advocate for free expression, First Amendment rights, and so forth. Although yet I have yet to see that actually take any real effect. But again, Commissioner Andrews, I think, will serve as vice chair very effectively, and I at least have some hope that he will take a look at issues that the public has tried to raise. One thing I think I will point out is that very often members of the public who get involved in city government, such as the Sunshine Posse, have all kind of given up on you. They don't even bother to come to these meetings anymore unless there's a particular issue that they want to raise because they know you're not going to respond. And very clearly, under the Sunshine Ordinance, you're not required to respond to any comment the public makes. But the law also equally says you are entitled to comment. And I think it's very telling that I can get up and say a whole bunch of things which really do make you look pretty bad, and not one of you has anything to say in response. Maybe with Commissioner Andrews as the vice chair, we'll get something other than what Mr. Herr usually gets, which is ridiculous looks.
Is there a motion to elect Commissioner Andrews as the vice chair?
So move.
Second. All in favor? Aye. Opposed? Hearing none, that motion passes. Congratulations, Commissioner Andrews. The next item on the agenda is discussion and possible action on the minutes.
Commissioner, we did find one last-minute typo that we missed before. On page 6, under the top of the page, under number 5, debarment, that first paragraph, the third to the last line reads, he stated that Chapter 28 is not explicitly lined. That word line should be linked.
Okay. Any other changes? Public comment. Is there a motion to adopt the minutes?
So moved.
Second?
Second.
All in favor? Aye. Opposed? Hearing none, that motion passes. Next item on the agenda is the Executive Director's report.
Just have one quick update on the work we've been doing on the language access ordinance. So we processed paperwork to encumber funds to begin translating documents. We have identified and engaged a specific translator. As soon as the paperwork is finished, we will send the first batch of documents to the translator. So we will have some documents done in this fiscal year.
Could I ask, in terms of the percentage of documents that we're talking about, what percentage that might be that will get done this year?
Of all the ones that we're going to do, at least half.
Thank you.
Yeah. And when I have those exact numbers of the money that we have, and by next month I'll have a good idea of the number of documents. But we expect to have 100% done within a calendar year from now, if not sooner.
Thank you.
Any questions for Mr. St. Croix and the Executive Director's report?
Thank you, Mr. Chair. Mr. St. Croix, I'm assuming under the enforcement summaries, in the stipulation that Chris Jackson entered into will take care of numbers 2 and 3?
No, this is in addition to those.
It's in addition.
Yeah. This is a settlement for violations. 2 and 3 are late fines for filings.
And number 2 is from 2011.
Right. And I believe that's the one that BDR has gotten a court agreement on.
Okay. I had a comment about this document, and I know I can't, but dates. I want to make sure that when we're doing this work, particularly in the enforcement work, that we have a timeline on all of the documents that come to the Commission, particularly on any of the complaints that are outstanding and pending, and any such documents that find themselves at the Commission. Right.
Sorry, just by way of, so just that there's that we're timely handling the complaints, yes?
That's correct.
Yeah, that's right.
Mr. Rennie?
I just, under the lobbyist program in your report, it says that as of March 15th, 126 individual lobbyists were registered to the Commission. On our audit, we had a list of lobbyists, not anywhere near 126.
That list is from last year. I'm sorry, did you?
So in terms of the choosing of who we chose to audit, the way we did it was we chose by firm as opposed to by individual lobbyist, because and the reason it was chosen that way is really our mandate is only to do one lobbyist audit a year. We thought 4 would be more appropriate. The issue is that when lobbyists report, if there are other lobbyists in the same firm, sometimes the reporting overlaps. So like one lobbyist might not report any income at all because the way our regs work is they can sort of have, if there are 3 lobbyists, one of them can report all of the firm's income. So, we didn't want to choose somebody and then, it turns out they had no income, but then it's this other person in their firm who's reported all the income. So instead of doing individual lobbyists in terms of, we just chose by firm. So if there's a particular firm where there are 3 lobbyists, we will actually audit all 3 of those lobbyists. And if there's a firm where it's just one person putting out their shingle, then in that case it would just be the one lobbyist.
Any other questions for the Executive Director? Public comment?
Commissioners, Ray Hartz, Director, San Francisco Open Government, and the report you're talking about is here on the screen. And down there at the very bottom, just above the word total, it says Sunshine Ordinance. And the interesting thing about these Executive Director reports is there's never anything there except a number. Never any explanation as to what's being done or what isn't being done or why it's not being done, just nothing. So when I got up here, I thought to myself, I should probably let the general public know that for their own edification that the responsibility for enforcing the Sunshine Ordinance rests with this body. But I had second thoughts about that. I thought, Gee, they don't even seem to recognize that fact. Years, literally years has gone by, and I'm not the only one with orders of determination that haven't been enforced. There are dozens, if not by now hundreds of people who've gotten orders of determination from the task force and can't get you to do a darn thing about them. And by doing so, whether you want to admit it or not, you are protecting elected officials who are committing fault. Luis Herrera, the city librarian, was accepting thousands of dollars. I brought that to attention of this commission. So did other members of the public, but nothing was done. We had to go to the FPPC in Sacramento and personally travel up there and testify to get them to do anything. And we have yet to get an explanation from the city librarian about why he filed statement of economic interest under penalty of perjury and lied and said he got nothing. And why he withheld public records from me on my multiple requests to hide that fact and to protect the Library Commission who approved that financial arrangement. And I'll say it once again, $70 million, and they don't know where the hell it went. And you can all sit there and just look, which is what you always do. You sit and look, but you don't say anything. I said this to the Library Commission. You know, I make a whole bunch of statements that sound really, really bad, and at any time, one of you could stand up and show that I'm wrong. The only problem is they can't because I'm not. And they just think, hey, if I sit quiet and don't say anything long enough, it'll go away. But it's not. I missed meetings here the last couple months because I was in Florida with my family. But I intend to be here at every meeting and make a comment every time until you get off your asses and do something about the Sunshine Ordinance. It's your legal responsibility. Will any one of you tell me that the law doesn't say you're supposed to enforce the ordinance? No, because you can't. That's what the law says. Question is, why aren't you enforcing it?
Next item on the agenda is items for future meetings. Any proposals from the commissioners? Public comment?
Ray Hartz, Director, San Francisco Open Government. When is one of you going to step up to defend the right of a citizen of San Francisco to go to a public meeting and make public comment without being harassed or belittled or somehow disparaged by members of boards and commissions who have the right to respond but do not have the right to shut people up? I went to a library commission just last week, and in the middle of my public comment, she says, oh, you can't talk about that. You can only talk about what we put on the agenda. In other words, if we don't put it on the agenda, you can't talk about it. Now, the task force has already ruled against the police commission for that very thing. Thomas Mizuko, who is a practicing attorney, tried to tell me I wasn't allowed at a police commission meeting to question how they handled one of the items on the agenda. And he forced me to sit down and shut up. I've watched him do it to other people. It's amazing that you go to boards and commissions in a city like San Francisco and really think that you have the right to speak until you start to put your little fist in somebody's rice bowl, as we used to call it in Hawaii. When you start to point out that the city librarian is accepting gifts from a group he's supposed to be monitoring and then lying about it on his publicly filed statements of economic interest. I keep saying that over and over again because I keep expecting at some point one of you is going to say, oh my God, that's terrible. It is. And it's even worse that private citizens had to go to Sacramento to get somebody to do something about it. Why? Because you won't. You're here to protect the people who appoint you. And I have news for you. As far as I'm concerned, the minute you take the oath of office, you no longer work for the person who appointed you. You work for the citizens of San Francisco. And you represent their interest and their interests alone. And allowing an appointed official, a city department head, to accept thousands of dollars worth of gifts from a group and do nothing about it, even though you're told point blank by members of the public that it's done, is unconscionable. Just like Supervisor Farrell, when we went to them approving the Friends annual appropriation, we went there and raised these same issues. And he acted like, oh, there's nothing wrong with that. And then he used his office to withhold public records because he didn't want to acknowledge that he really hadn't looked at anything. He voted that the full Board of Supervisors approve the appropriation without having him or any of his staff look at a single document. That's what they admitted at the task force hearing. They came forward and said, we didn't give Mr. Hartson anything because we didn't have anything. So they took it into a committee and they voted to recommend to the full Board of Supervisors that they approve the appropriation without ever making any attempt to look at what that appropriation was. Unbelievable. But you all just sort of sit there with blank looks in your eyes, and I don't know. I really do wonder about you guys.
Is there a motion to adjourn the meeting?
So moved.
Second.
All in favor? Aye. This meeting is adjourned.